The PDP chief Mehbooba Mufti is claiming that she's been put under an illegal house arrest. From the social media handle of JNK PDP, these images have been shared, but now an immediate rebuttal has come in from the Jammu and Kashmir Lieutenant Governor Manoj Sinha, making it absolutely clear that nobody is under house arrest. He's given out a statement, not wasting much time. Remember, for Kashmir Valley, this is an important issue. This is sensitive as well, and therefore no rumour mongering to be allowed as well. Jammu and Kashmir's Lieutenant Governor has said, and I want to just quote him here, on reports of JNK leaders being put under house arrest ahead of the Supreme Court verdict on abrogation of Article 370, he has said this is totally baseless. No one has been put under house arrest or arrested due to the political reasons. It is an attempt to spread rumours. Ashraf Wani is joining me on the latest on that. Ashraf, without wasting any time, Jammu and Kashmir Lieutenant Governor himself putting out a video statement stating all of this is baseless. So what are you hearing right now? What has the LG said? What is the PDP saying?
Pooja, not only the Jammu and Kashmir Lieutenant Governor Manoj Sinha has come with the statement that nobody is under house arrest in Jammu and Kashmir. Also now it has been followed by the Jammu and Kashmir police. They have also claimed on the social media that not any political party, particularly Mehbooba Mufti, is under house arrest. That means that now a new game of politics started on the verdict of the Supreme Court on Article 370, which is yet to come. So the Jammu and Kashmir government wants to make it clear that after the abrogation of Article 370, things had changed on ground, particularly in the Kashmir Valley, and there is not any kind of restriction now on the people. We have yesterday seen there was a big rally by the former Chief Minister Umar Abdullah in the Rafiabad area, Baramulla district. That was also allowed, not only allowed, but even in fact facilitated by the Jammu and Kashmir government and police in the Baramulla. And that means that the Jammu and Kashmir administration and the Lieutenant Governor want to also showcase that the things had changed after the abrogation of Article 370 here in the Jammu and Kashmir, particularly in the Kashmir Valley, and things are well in the control. But the police as well as the administration earlier said that they are taking some precautionary measures. The Jammu and Kashmir police as well as the security agencies had been put on high alert so that any kind of untoward could not happen, or there could not be any kind of a law and order issue after the verdict by Supreme Court. That is why we have seen some presence of the security officials.
So I'm going to now play out what the Lieutenant Governor Manoj Sinha of Jammu and Kashmir had said with regard to it. Remember, minutes after PDP claiming that our chief, our leader, has been put under house arrest, here's what the Lieutenant Governor of JNK has to say. Let's listen in how he's rubbishing these claims.
ये पूरी तरह से निराधार है. पूरे जम्मू कश्मीर में न ही किसी को हाउस अरेस्ट किया गया है, न ही किसी की गिरफ्तारी की गई, और ये भ्रामक अफवाह फैलाने की कोशिश है. मैं बड़ी जिम्मेदारी से बात कर रहा हूं कि पूरे जम्मू कश्मीर में राजनीतिक कारणों से किसी को न गिरफ्तार किया गया है, न हाउस अरेस्ट किया गया है.
All right, Jammu and Kashmir's Lieutenant Governor Manoj Sinha saying that this is absolutely false, baseless. Nobody has been put under house arrest for political reasons. It's a brief comment that has come in from LG Sinha. But remember, the understanding the gravity of the situation right now, LG immediately responding to the claim or what has been made by the PDP. We'll wait for if there are further reactions coming in from PDP or Mehbooba Mufti. Let's now from the Kashmir Valley to Delhi, the Supreme Court. The live streaming visual on your screen. The judges, the 5-judge bench, have not taken their seats now. In just a few minutes right now, we will be expecting that big verdict to be read. From 2019, remember when this decision was taken by government at the centre and the parliament, this was a big risk. It was a region that has been embroiled in conflict for at least 30 years, if not more. It has seen violence, bloodshed, hundreds of people, not just from the security forces, but from the Kashmir Valley, youngsters who lost their life as well when they were pushed into violent maneuvers like stone pelting and others, and then there has been firing too. And all of this is not seen in the past 4 years in the Kashmir Valley. There have been a lot of other development measures that have been taken. There have been equal rights that have been granted to those refugees who had come and stayed, or the migrant workers who were living in J&K. But today is not about the ground reality. It is as much about the constitutional validity. Anisha Mathur at the Supreme Court premises, Nalini Sharma joining me from the newsroom. Anisha, go ahead now, because it's going to be as much about the arguments that we have heard. What do you pick from the arguments that were during the hearing from the petitioners and from the government? Because the government is very clear that this decision was taken with the changes that were kept in mind of what can happen. It was about an equality-inducing measure that had to be brought in for Jammu and Kashmir's integration, because this was being misused by the separatists and the Pakistan-based proxies. Over to you, Anisha. What was the government reasoning and the petitioners?
Well, Pooja, to tell you, the government's reasoning has been, as you just said, the government had pointed out that the issue is of equality, of equal status within the Constitution of India for all states. They had also said that there are concerns with regard to the especially Article 35A of the Jammu Kashmir Constitution. Also the fact that existence of a separate constitution, a separate legal system in a state was leading to alienation. Those were the arguments by the Government of India. Additionally, the Government of India had also said that it is the Parliament of India which is the supreme representative of the will of the people, and therefore, even if while the initial argument was that there is no mandatory requirement for a recommendation or a consent being given by the assembly or the elected assembly of the state itself, the Parliament could also give consent, because Parliament is the inheritor of the Constituent Assembly. Now remember, these are very nuanced legal issues. What the says that after the Kingdom signed the of succession, after the Constitution of Jammu Kashmir was made, and in 1956 after J&K integrated into the Government of India, all the powers of the Constituent Assembly, which is the body which had created the Constitution of Jammu and Kashmir, allowing the integration of Jammu Kashmir into India, those powers were now inherited by the Parliament of India, which means that according to the centre, it is the Parliament of India which had the power to take a decision with regard to the abrogation. On the other hand, the petitioners, which are the political parties and activists, etc., in Jammu Kashmir, say that this is not how it goes. Their argument is that it is the elected legislature which is has the power to give consent to abrogation.